Hello friends, in the series on the income tax cases, today we will discuss a case on section 271D. Section 271D talks about penalty for failure to comply with the provisions of section 269 SS. And section 269 SS talks about mode of taking or accepting certain loans, deposits and specified sum. Section 269 SS was amended with effect from 1st June 2015, in which the cash payment related to the sale of property was also included, meaning thereby that if the assessee receives cash for the sale of the property, then section 269 SS will be attracted and the assessee will be penalized for accepting this cash under section 271D. The moot question before the Amritsar Tribunal in the present case was that if the assessee was under a bona fide belief that section 269 SS is not applicable to those transactions or for those properties which are held as stock in trade, then in that case whether the penalty under section 271D is justified. This issue has been taken up by Amritsar ITAT in the case of Aggarwal Construction Co versus Deputy Commissioner of Income Tax, and this case is reported in 116 ITR Tribunal at page number 372. The date of the judgment is 28th September 2024. The present case relates to the assessment year 1617. The assessee is a civil contractor and he has sold developed plots of land during the previous year which was relevant to the assessment year 1617. The assessee had received 21 lakh of rupees in cash, and on which the assessing officer has initiated the proceedings under section 271D. In the proceedings of section 271D, it was the plea of the assessee that the assessee was under a bona fide belief that section 269 SS is not applicable for those transactions or those properties which are held by the assessee as a stock in trade. But the assessing officer was not satisfied with the submissions of the assessee and he imposed the penalty and passed the order for imposing the penalty under section 271D. When the matter came before the learned CIT appeal also was of the same view that the assessee is not able to prove his case under section 273B, that is for reasonable cause, hence the penalty is justified. When the assessee carried this matter to the tribunal said that in the present case, the assessee is able to prove that he was under a bona fide belief that the provisions of section 269 SS were not applicable to the immovable property held as stock in trade. The tribunal said that in the present case, the assessee has recorded all the cash received in the books of accounts. The assessee has disclosed it in the return of income and has accordingly paid the tax on it. The tribunal said that in the present case, there is no revenue loss to the government. There is no deliberate defiance of law by the assessee, and the assessee is not dishonest and has not acted in conscious disregard of any legal obligation. The tribunal said that even if there is any breach of law, then it is not bona fide in the present case. The tribunal said that the cash payments are legally acceptable and it is also very apparent that the cash has been received by the assessee before the government registered authority and the sale deed is duly registered under his stamp and signature. So in the present facts and circumstances, since the assessee has paid tax on that and the assessee was under a bona fide belief that these provisions are not applicable to the transactions of the assessee because the properties are held as a stock in trade, so section 271D penalty is not justified. So friends, the takeaway from this case is that if we are able to justify that there is a reasonable cause, then the penalty under section 271D is not automatic. At the end of this video, once again I am repeating the name of the case. The name of the case is Aggarwal Construction Company versus Deputy Commissioner of Income Tax, and this case is reported in 116 ITR Tribunal at page number 372, and the date of the judgment is 28th September 2024. Thank you, friends.